Let's talk about the Philippine Mining Act of 1995 under exploration permit, mineral agreements, financial and technical assistance, and the quarry resources. With regard to exploration permit of the said act, exploration permit grants the right to conduct exploration for all minerals in specified areas. The Bureau shall have the authority to grant an exploration permit to a qualified person. In short, the exploration permit is an authorization for the grantee to spend its own funds on exploration programs that are pre-approved by the government, without any right to recover anything should no minerals in commercial quantities be discovered. The exploration permit serves a practical and legitimate purpose in that it protects the interests and preserves the rights of the exploration permit grantee, the would-be contractor, foreign or local, during the period of time that it is spending heavily on exploration works without yet being able to earn revenues to recoup any of its investments and expenditures. An exploration permit shall be for a period of 2 years, subject to annual review and relinquishment or renewal upon the recommendation of the director. The maximum area that a qualified person may hold at any one time shall be onshore in one province, for individuals 20 blocks, and for partnerships, corporations, cooperatives, or associations 200 blocks. Onshore in the entire Philippines, for individuals 40 blocks, and for partnerships, corporations, cooperatives, or associations 400 blocks. Offshore beyond 500 meters from the mean low tide level, for individuals 100 blocks, and for partnerships, corporations, cooperatives, or associations 1,000 blocks. An exploration permit shall grant to the permittee, his heirs or successors in interests, the right to enter, occupy, and explore the area, provided that if private or other parties are affected, the permittee shall first discuss with the said parties the extent, necessity, and manner of his entry, occupation, and exploration, and in case of disagreement, a panel of arbitrators shall resolve the conflict or disagreement. The permittee shall undertake an exploration work on the area as specified by its permit based on an approved work program. Any expenditure in excess of the yearly budget of the approved work program may be carried forward and credited to the succeeding years covering the duration of the permit. The Secretary, through the Director, shall promulgate rules and regulations governing the terms and conditions of the permit. The permittee may apply for a mineral production sharing agreement, joint venture agreement, co-production agreement, or financial or technical assistance agreement over the permit area, which application shall be granted if the permittee meets the necessary qualifications and the terms and conditions of any such agreement, provided that the exploration period covered by the exploration permit shall be included as part of the exploration period of the mineral agreement or financial or technical assistance agreement. A holder of an exploration permit who determines the commercial viability of a project covering a mining area may, within the term of the permit, file with the Bureau a declaration of mining project feasibility accompanied by a work program for development. The approval of the mining project feasibility and compliance with other requirements provided in this act shall entitle the holder to an exclusive right to a mineral production sharing agreement or other mineral agreements or financial or technical assistance agreement. An exploration permit may be transferred or assigned to a qualified person subject to approval of the Secretary upon the recommendation of the Director. Mineral Agreements of Philippine Mining Act, Section 26 provide the modes of mineral agreements. Mineral Production Sharing Agreement or MPSA is an agreement where the government grants to the contractor the exclusive right to conduct mining operations within a contract area and shares in the gross output. The contractor shall provide the financing, technology, management, and personnel necessary for the implementation of this agreement. Co-production agreement or CA is an agreement between the government and the contractor wherein the government shall provide inputs to the mining operations other than the mineral resource. Joint venture agreement, or GVA, on the other hand, is an agreement where a joint venture company is organized by the government and a contractor, with both parties having equity shares. Aside from earnings in equity, the government shall be entitled to a share in the gross output. The maximum area that the qualified person may hold at any time under a mineral agreement shall be: for individuals in onshore in any one province, 10 blocks; in Philippines, 20 blocks; offshore beyond 500 meters, 50
While
blocks.
this is the maximum area of partnerships, corporations, cooperatives, or associations.
For the exclusive economic zone, a larger area to be determined by the Secretary. The maximum areas mentioned above that the contractor may hold under a mineral agreement shall not include mining quarry areas under operating agreements between the contractor and the claim owner entered into under PD number 463. For the question of where to file, all proposed mineral agreements shall be filed in the region where the areas of interest are located, except in mineral reservations, which shall be filed with the
Will be
Bureau.
approved by the Secretary and copies submitted to the President.
He will provide a list to Congress within 30 days from its approval by the Secretary. For the question who are eligible, in case of an individual, he must be a Filipino citizen of legal age and with capacity to contract. In case of a corporation, partnership, association, or cooperative, must be organized or authorized for the purpose of engaging in mining, duly registered in accordance with law, at least 60% of the capital of which is owned by Filipino citizens.